Go back on the record. Morning, DDC.
Okay.
Good morning, sir. State your name, please.
Larry Samuel.
Larry Samuel. Thank you. Good morning, Mr. Samuel. This is case 25058-306, People State Commission versus Larry Odell Samuel. Appearance for the people.
Thank you, Magistrate. Good morning. As you know, always a pleasure. Steve Vincent for the people, P71917.
Where's the former reason complaint stands due, what's the disciplinary not on his behalf, as to all counts.
And both of them. Probable cause scheduled via Zoom, July the 3rd. That's a Thursday, 8:30, 36th District.
Risk, and he's continued with the OWI because nobody observed him driving. But he was found in a vehicle, unconscious, with multiple open containers of alcohol. The police ended up noting that this was slurring his speech. His eyes were watery. His car apparently was parked on a sidewalk. Now, Magistrate, I say all of this, those allegations are bad. Wasn't charged with the OWI, has the open alcohol charge, has the R&O because the police were trying to get him out of his vehicle. He was resisting, has the DWLS because while he was doing all of this, he didn't have a license. But Magistrate, I looked through this defendant's history. In September of 09, this defendant was convicted of his second OWI out of the 17th district. He got jail as well as 18 months probation. 5 years later, he was convicted in Oakland of his third OWI. He ended up receiving jail as well as probation, on top of the fact that he was convicted of a DWLS. And then 2 years after that, in 2016, here in 36th District Court, for whatever reason, he wasn't charged with some type of HAB or enhancement. He was convicted of an OWI, also given 18 months probation. So I have—
So that's his fourth conviction?
Right. 1, 2, 3, 4. Yeah, there are 4. And now I have an individual who's found unconscious behind the wheel with the car parked on a sidewalk with a liquor bottle that's open as well as a beer bottle. And the police ended up observing, all of these things, observed his, signs of intoxication. But ultimately, the OWI wasn't charged because nobody saw him driving. But clearly he was behind the wheel, and clearly he had alcohol in his car. It was in the council that was readily available to him. So we feel as though he's a danger, Magistrate. I understand he's being charged with the R&O, but we also have that open alcohol. He does have a problem. And apparently he just continues to do this all the while without a license because he's being charged with the DWLS, which seems like it's been attached to at least 2 of these prior alcohol offenses. So we're asking for the 10%. We're also asking for the monitorization.
Your Honor, may I have—
For one moment, sir. You have an attorney here that's going to speak on your behalf. If you have any questions or anything you want to say, just let him talk and you'll have your opportunity. Go ahead, Counsel.
Thank you, Mr. Samuel. Judge Miguel Brick on behalf of Mr. Samuel. I understand the people's position on this matter. I understand the charges that we're dealing with. I just want to clarify for the record, as far as my knowledge pertains, there's some mention of having the OWI 4th. I believe he's only had the OWI 3rd conviction in the past. Today, he's not here in front of you for any OWI related offenses. He's here for the operating without a license. He's here for the resisting or obstructing of an officer and for the open container. Judge, I would be asking you on this matter for a personal bond. I have no objection to any alcohol tether requirements. I have no objection to any monetization requirements. It's primarily that monetary issue that we have to find to keep them in pretrial detention due to monetary reasons, Judge. It would be an unaffordable bond if we were to impose a monetary bond. Just to give some insight, he was not charged with OWI. He's not here on an OWI. My client does have his side of the story, which I'm not going to litigate here today, but there is some credence to the fact that there were other individuals in the vehicle with Mr. Samuel. So I do understand that this court has two objectives, one for flight risk and the other for danger to the public. I don't have a reason to believe that he will not show up in future court dates. What I believe this court is mostly concerned with is Mr. Samuel getting behind the wheel and hurting somebody. So I would ask you to impose a personal bond. I don't have any objection if you were to impose an alcohol tether. I think it may be to the benefit of my client if you were to do that, or any other minorization that you think is necessary, no driving order at all. And he should understand that for interview with him that he's not to be in a vehicle behind a wheel at all. So that's where I stand. He's a lifelong resident of the city of Detroit, has provided us an accurate address and phone number, and does work at Chrysler, and provided us a time for those shifts as well.
Thank you. Mr. Sam, you have heard counsel advocate on your behalf. You've done a good job. If you have anything to say, let me speak and you'll have your opportunity. Mr. Samuel, these are very serious allegations. They are non-assaultive. I've reviewed the investigator's report and taken into consideration your prior criminal history, which concerning to the court, given these allegations are your multiple convictions for operating while intoxicated. I believe you have around 4. And that's highly concerning given these allegations that you were driving a vehicle, you're charged with operating suspended. That's the allegation that you were driving a vehicle. You have a count 2 operating while suspended, revoked, denied. And the allegations further is that the officers observed you unconscious after an auto accident behind the wheel and observed 2 open containers of alcohol, Randy Martin and a Corona 12-ounce located in the center console of the vehicle. Again, this allegation was an accident. You have multiple convictions previously for operating while intoxicated. After review the investigator's report, I don't have any information regarding any habeas history. Your employment status at Chrysler is taken into consideration as it relates to the ability to post bond. I think your counsel on this one has spoken accurately about the court's concerns and addressed them. I will follow his recommendation and that you'll be released on a $25,000 personal bond. Mr. Samuel, you don't have to post any money. During this bond, I'm giving you certain conditions, and these are all without objection from your counsel. And